she would file a dismissal for the BPO. She did not do so. She did not file for an enforcement motion either that I requested her to do before Christmas. She told me that she had a rape case that she had to attend to that was more prior and important at that time. And we did not meet, so we did have a lack of communication. I feel as though she put more of her effort into the rape case and not mine. And so there was a breakdown of communication, and we're here today without any sort of, communication at all. So I agree with her motion to withdraw.
All right. Ms. Yeager, did the state wish to be heard regarding the motion?
No, Your Honor.
All right. So the ethical guidelines for the practice of law do allow for withdrawal of representation when there's been an irreparable breakdown in communication. That's not uncommon. I've presided over and made rulings on motions of the same nature countless times. What's unique about this case is the fact that, number one, the Ohio Public Defender was cooperative enough to agree to allow one of their staff attorneys to actually come to Licking County, where we do not have a public defender's office, to represent Mr. Bishop, because Mr. Bishop has now blown through, on one case, let's see, 1, 2, 3, 4, 5. Ms. Ilola would be the 6th attorney that had been appointed to represent him. In the other case, at the very least, she would have been the 5th attorney that was appointed to represent him. The court does not force attorneys to continue with representation when they feel that there cannot be an adequate resolution. Furthermore, the defendant has expressed his displeasure. Now, at this time, I am going to grant the motion to withdraw, and Ms. Ilola, if you would like to leave, you're free to go.
Thank you, Your Honor. Before I do, though, I do want to make a record. Mr. Bishop did hand me a lot of materials to look over, which I did do so for his case. I would like to hand them back to him on the record, just so that way we do not have any further issues going forward. This is everything, including the flash drives that were given to me, and then including the new motions that were addressed, this is the motion to withdraw that was sent to you also, but I wanted to give you a copy of it in person as well.
And Mr. Bishop, are you satisfied that Ms. Ilola has returned everything that you had provided to her?
I believe so, Your Honor, with a quick glance over.
Very well. Counsel?
Your Honor, I just wanted to make sure, clarify, does that include all the discovery provided by the state?
I believe so. Based off of what I was given by Mr. Bishop, I believe that's all the discovery as well.
All right. Thank you, counsel.
Thank you very much, Your Honor.
Okay, so a couple of matters that we need to address. Number one, the defendant, pro se, prior to the withdrawal of Ms. Ilola's counsel, filed a motion to enforce. That was filed on the 16th of January. In essence, the defendant is asking this court to order a different court to take legal action. This court has absolutely no authority to do that. Certainly, the defendant could seek a writ of mandamus from the Ohio Supreme Court, asking it to order the Domestic Relations Court to proceed. But
Repeat
this,
that? I barely can hear you. I'm sorry.
well, here's the thing. This court does not have any authority to tell another court what to do, all right? So I'm going to deny your motion to enforce. Now, there are certain other steps that you can take to try to get the relief that you sought from this court, but obviously that's something that you would have to do at this point on your own. Now, the other thing that was pending, and has been pending for a while, is the defendant's motion in limine regarding the use of a recording which purports to capture a conversation between the defendant and at least one, if not several, individuals at the Domestic Relations Court. The allegation being that the recording itself was made not by Mr. Bishop or the individual that he was speaking with, and in fact the state seems to concede that fact in its memorandum contra the motion to in limine. And the court did considerable amounts of research yesterday afternoon, and here is basically what I found. Normally, a statutory violation is not remedied by exclusion. For instance, if an officer stops an individual for operating a vehicle while impaired outside of their territorial jurisdiction, that's actually a violation of law. But because it's not a constitutional violation, a defendant would have absolutely no relief or recourse to seek any type of exclusion. Here, however, there are specific statutes, I should say, that number one, prohibit and outlaw the interception of oral communications, and there are specifically statutes that indicate, and I will quote, no part of the contents of any intercepted oral communication shall be received in evidence in any trial if the disclosure of that information is in violation of sections 2933.51 to 2933.66 of the Ohio Revised Code. That's 2933.62A. 2933.52A1 prohibits the interception of an oral communication, and the subsection A3 of the same statute prohibits the use of the contents of the intercepted oral communications. So it would appear that the defendant's motion in limine is well taken, and I will preliminarily grant that in order that the defendant, or that the state, not use the recording itself in its presentation of evidence in its case in chief. That does not preclude the state from introducing evidence from individuals who were either part of the conversation or individuals who overheard the conversation as it occurred and who have a source of knowledge of the contents of the communication, not from the recording, but rather from their own auditory senses. So the court will be putting on that entry. Now we need to address the issue of counsel, or maybe we probably should have done that first. It doesn't really matter, because the last time we were here, when Mr. Iteum withdrew his counsel, the court did indicate and explain to Mr. Bishop that I would be reaching out to the Ohio Public Defender's Office to see if they would be willing to represent him. Thankfully they were, and I explained to him that if they weren't, or if that didn't work out, that the court would very likely declare what's called a constructive waiver of counsel. So I've done a little research in that regard as well. There's a case out of the 5th District, actually, from April of last year. It's in re adoption of AMV. It's 2024 Ohio 1240 is the site. But basically it talks about the fact that in that case, 2 separate attorneys were appointed to represent the defendant in a parental rights matter. The rights are conveyed under a different authority than the constitutional, but it's pretty much related. And then after the putative father basically fired both of those attorneys, the court reached out to every other attorney on that county's court-appointed list, all of whom declined to represent the putative father. And the ultimate ruling was that the defendant had 2 options at that point. He could, A, hire his own private counsel of his choosing, or B, represent himself. But at this point, the court finds that it has done everything possible to afford Mr. Bishop his right to court-appointed counsel, but that if 2 were enough in that particular case, I think 5 is more than enough in this one. So the court is going to declare a constructive waiver of the right to court-appointed counsel, and I will explain to you, Mr. Bishop, that you have 2 options. Number 1, you can hire your own attorney using your own funds. Number 2, you can represent yourself. You understand that those are the 2 options you have?
Yes, Your Honor. May I have a chance to speak now?
As soon as I'm finished.
Yes, Your Honor.
I need to advise you of the perils of self-representation. I want to confirm with you that you did not go to law school, nor do you hold a law degree, correct?
Correct.
You've never been admitted to the bar of any state to practice law, correct?
Correct.
Well, here's the thing. If you elect to represent yourself in these cases, you will be held to the same standard as somebody who has been to law school, who has passed the bar, and who has the experience of practicing in the courts of Ohio.
The judge makes it clear that representing yourself comes with serious consequences. Mr. Bishop argues that his attorneys refused to fight the case the way he wanted, but the judge pushes back, explaining that disagreement with an attorney does not mean the attorney was ineffective. After going through 5 appointed lawyers, the court decides that enough has been done to provide him with counsel, and he now has to choose between hiring his own attorney or representing himself.
Not be permitted to advise you on how to proceed. You could very well miss certain opportunities to improve your circumstances or plead your case. And that would be a risk that you would be taking by the fact of refusing to accept the assistance of court-appointed counsel.
Objection to that motion right there, Your Honor. I didn't refuse counsel. They've refused me. I would like that worded correctly. Sorry.
Well, Mr. Bishop, here's the thing.
They have all told me.
Here's the thing, Mr. Bishop.
Yeah.
Them not telling you what you want to hear is not the same as being ineffective, okay?
That
You may disagree with what they have to tell you, but they know more about the law than you do. I'm fairly confident in stating that.
That wasn't the case, Your Honor. I was being forced to take a plea deal when I wanted to come to trial. That is illegal. That is against my judicial standards of right. Every single attorney you have given me so far has told me to take the disorderly conduct on this telephone harassment and they'll dismiss the VPO. And every single one of them has told me this plea deal that they are going to come to the prosecutor with and that they want me to take that. And I've said, no, don't you dare go to the prosecutor with that. I want a trial, and that's what I want. And they have all came up with this phenomenon of a idea. Every single attorney. And when I say, absolutely not, I want a trial, let's prepare for trial, next thing you know, we get a withdrawal motion. Me and her didn't have no quarrel. She just put her efforts into a rape case over me. And that's the same thing with that Ed guy. He put that whole situation, same thing with the previous attorney, Todd, or what have you, his name. And then I also want to put on the record, Your Honor, that out of the 5, 2 of them never even called me. I never even was aware that they were appointed to me. And they never even emailed me, called me, nothing. There was no mail, nothing. I wasn't aware that even 2 of those 3 came forward. All I knew about was Zach Tabler, Atilium, Todd something, and this Ariel Iolia. And that is it. 4 attorneys. That is it. The other one, and you had told me last time we came that there was 2 or 3 of them that withdrew themselves, Your Honor. I've never even seen or talked to them. I didn't even know they were my attorneys appointed. So, on the fairness side of things, I have not had fair representation, so I do want that to be put on the record that I have not had appropriate representation. That's why we've went through so many of them. And there was a $20 million lawsuit against the previous magistrate in this county, and all of the attorneys are aware of it, telling me, on record, I want this noted, that they are all workers of this city, and that they do not want to help me in this matter.
Well, Mr. Bishop, quite frankly, I'm a little tired of your conspiracy theories that everybody's out to get you or force you to do things. No attorney that's ever practiced in front of me has forced an individual to accept a plea.
I have video
Nor
record.
Mr. Bishop, it's my turn to talk.
Sorry.
Nor have I ever accepted a plea that wasn't knowing, intelligent, and voluntary. That's why you saw me go through those questions with the 2 individuals who did, in fact, enter pleas in their cases before we called your case to be heard today. I will put on the record that in at least one of the motions to withdraw, there have been allegations of verbal abuse by the defendant towards their attorney, and there have been informal allegations that perhaps there may have even been threatening language used towards those attorneys. So the defendant's objection is noted, but he has waived his right to have court-appointed counsel by basically plowing through these attorneys. And whether it's 5 or whether it's 3, I can't get anybody else to accept representation of you, Mr. Bishop. Now, certainly, you've indicated that you want to have a trial, and the court is more than prepared to afford you that option. And after today, we will be scheduling this matter for a trial by jury. The court will make a determination as to which case we're going to handle first, because I do not believe these are consolidated, are they?
They are not consolidated, Your Honor,
Your
however.
Honor, can you explain what consolidated means?
Meaning they would be heard together at the same time.
They are not consolidated at this juncture, however, we would be able to try them both at the same time.
Well, the court finds that they're 2 separate and distinct matters, and in the interest of safeguarding the defendant's rights against undue prejudice, I do believe that they're completely unrelated in that one involves an allegation of harassing phone call to court personnel, where the other simply involves an allegation that a phone call was made to a school where the defendant's children were enrolled, but that he was subject to allegedly a protection order that prohibited him from contacting the children's school. So the state certainly is welcome to file a motion to consolidate, but as former Judge Harris of the Fairfield County Municipal Court said, although I won't prejudge anything, you'll lose. That being said, we will schedule this matter for trial probably within about the next 30 days, Mr. Bishop. If you, in fact, retain private counsel, by all means, make sure that they submit their notice of representation in a timely fashion. If you elect to represent yourself, if there were ultimately a conviction on either one or both of these charges, you would certainly have the right to appeal my decision declaring a constructive waiver of counsel to the Licking County Court of Appeals. What was it you wanted to say?
Thank you, Your Honor. I'm sorry. If I don't speak, I lose it. So I'm not my father, so I'm not a professional, as you said. So I'd like to just make a motion right now. I was under the impression we were going to trial today, and that is what I came here prepared 100% for a trial today for the VPO. I am going to ask for a continuance and ask that we push the telecom harassment out for a few months because I do want to retain counsel. I'm going to sell my father's Mustang and retain counsel. So it's going to take me at least a little while, and I'm in school right now at CTEC for 5G broadband. So and it's already paid for. I've already put $2,200. This case is over a year. My life doesn't stop. I've got kids. I got child support. I have to work and I got to go to school. So I'm asking that my graduation is after March 20th. We've pushed this out this long. I ask that if we do the telephone harassment, that we do that one past March 21st so I can graduate. As for the VPO, I would like to make an oral motion right now and agree to your waiver to counsel for myself, and I don't need appointed counsel. I will represent myself on a separate matter of the VPO, and let me get the case number for you, Your Honor, for the record. Do you want me to stand on this, Your Honor?
You don't need to stand when you address the court. That's all right.
I would like the case number 23 CRB 1774A to note that I will represent myself on the VPO,
Okay.
and that I am going to request today as well an oral motion of dismissal because I was under the impression of a trial today. I am prepared for trial. If state is not prepared for trial today, I ask that they withdraw and dismiss.
All right, Ms. Yeager?
Your Honor, Mr. Bishop speaks prematurely about our preparedness. However, in speaking with court staff yesterday, we were instructed to call off our witnesses for the VPO case. So we would be unable to proceed, but we did that based on the impression that this matter would not be going forward today. Regarding...
Objection.
You have to let her talk, Mr. Bishop.
Regarding the pushing the telecommunications harassment case to after March, we would object to that. These cases are from 2023. This has already gone on long enough. The defendant has a right to a fair trial, but the victims also have a right to a speedy trial as well. So we would object to just pushing that just so that he can graduate and sell his father's Mustang. Those are things that he should have already been prepared for. And since he did mention a disorderly conduct, we did want to just clarify for everyone, the state's offer has never been for a disorderly conduct. The state's offer has always been plead to the telecommunications harassment, and we would dismiss the protection order violation case. That's still what our offer is. However, if we do go to trial, we will be prepared to go to trial on both. Thank you.
Alrighty.
Your Honor, that didn't address my motion to dismiss.
And we are not dismissing.
The hearing finally comes to a close. Mr. Bishop has waived his right to court-appointed counsel in the protection order case and will move forward representing himself. The judge explains the risks of self-representation and the potential penalties he faces. The court then recesses and schedules the next court dates, while the prosecutor confirms that future communication can take place in court or in writing.
By counsel of your choosing, by hiring somebody, you have the right to apply for court-appointed counsel, which you've done, and which the court has granted on numerous occasions in this particular matter. Obviously, the court was declaring a constructive waiver of counsel, but if you're affirmatively waiving that, we just need to put that on the record and have you sign off on it. Be advised, representing yourself exposes you to a number of pitfalls and dangers. Self-representation is never recommended by any court that I've ever known because laypersons do not always know exactly how the law works or what the law is, what procedure is, but you would be held to the exact same standard as somebody who was trained and who was licensed to practice law. Do you understand that?
Yes, Your Honor.
And as far as that's the protection